జూమ్ చేయనా? అంటే వెనకాల బ్యానర్ కనపడదు కదా. This meeting is being starting. Got it. I'm still looking. Sorry. Sorry. This is fine.
This is fine.
Starting with three frames are side kill.
Hey, you go front, no? Front side. That AC wala side. Fine.
Anish.
Request all the participants to kindly rise for the prayer panel. Thank you, everyone.
Apologies, Your Lordship. Your Lordship, readings of the date, report 27, appearing on behalf of the appealants. I, as Counsel 1, would be dealing with the issue of maintenance as the issue of agreement, and I will be taking minutes of the bench. Your Lordship, my co-counsel shall be dealing with the issue of abuse of dominant power and shall be taking 10 minutes of the bench. Would Your Lordship prefer a time for use of the fact before moving forward with the much obliged, Your Lordship. Moving forward with the issue, Your Lordship, the first issue at hand is the issue of maintainability. Your Lordship, Article 136 provides for discretionary power of the Supreme Court to grant special relief for appeal. This appeal power is discretionary in a nature that it can be exercised in spite of special provisions of appeal that are present inside Constitution or other provisions of law. Your Lordship, exhaustion of alternate remedies is also not a prerequisite for filing of a application under the any order, any tribunal can be heard in the said matter, as well as the word order in the said article is not qualified by the word final. Therefore, Supreme Court is empowered to hear appeals against interlocutory as well as interim orders as well. Your Lordship, the Council shall be dealing with the issue of maintainability in Informed argument. Firstly, proving that the CCI is a tribunal under Article 12. Secondly, that there was a violation of principle of natural justice. Thirdly, that there exists a substantial question of law. Article 136. Much obliged, Lordship. Your Lordship, moving forward with the first limb of the argument. That is, first limb is CCI is tribunal under Article 136. Your Lordship, if it is considered the case of Bharat Bank employees, while clarifying the expression tribunal, the Supreme Court has expressly laid down a twin test which states that if the adjudicating body is established by the state, as well as it is vested with judicial powers, which shall be considered as a tribunal. Moving forward, Your Lordship, in the case of Mahindra Electric Mobility, PCI has been adjudged as a quasi-judicial body. Further, it has been established by state under Section 7 of the Competition Act itself, and it exercises powers of judicial nature under various sections such as Section 3 and Section 4, and owing to the regulations number 10, 12, 15, 24, 28, and others. Further, Your Lordship, Section 61 expressly bars jurisdiction of civil courts in the matters of competition. Therefore, Your Lordship, it qualifies the twin test for being a tribunal under Article 136. Moving forward to the next limb of the argument, Your Lordship, that is the violation of principles of natural justice. Your Lordship, Article 136 can only be exercised in exceptional circumstances leading to miscarriage of justice. Thus, if a tribunal acts in violation of principles of natural justice, it can be said to be a matter of can be considered under Article 136. Your Lordship, the rule requiring reasons to be given in support of an order is like rule of order as a partum. Further, in the case of Devdutt, the Supreme Court has specifically quoted that transparency and good governance are new dimensions of principle of natural justice. Your Lordship, the order that is in challenge is the common order passed by Competition Commission of India. Right. And that order was dismissal. Your Lordship, it was a common order. One of the petitions have been accepted and the other complete has been dismissed. The appellant is aggrieved because it is causing double whammy to the appellant, as the application that was made against the CPLC, that is our client, has been accepted, and the application that was made by CPLC against the companies that are cartelizing against CPLC or to oust it out of the market was dismissed. That is not applicable. Your Lordship, it is appealable, but considering the facts and the exigencies of the case and the substantial portion of law that is involved, apart from the principle of natural justice that was being violated because of absence of reasons that were given with the order. One thing I just wanted to understand: if there is a statutory remedy, provisions are in very material. The appeal lies before the appeal tribunal. But you say there is lack of vision.
And therefore, the highest court of the land should supply the regions for the regulator, which does not give any regions, and that is why you are before us. Your Lordship, it is not only lack of reasons, but also the presence of substantial portion of law that just if you have any precedent on this point, where a tribunal, there is a regulator which is passing an order without regions, and the Supreme Court will start interfering and start giving the regions for that. Just some ruling if you can cite on that.
Your Lordship, the petitioner have cited the case of Deepak. Your Lordship, it has been quoted on page number 16 of the memorial, citation number 16, that is Deepak versus Union of India in 2003. Your Lordship, the case specifically was before Supreme Court, where Supreme Court emphasized that transparency and good governance has been added as a new dimension of natural justice, which also includes duty to give reason. And if such a thing has been included in principles of natural justice by the Supreme Court itself and the Commission, that is a lower judicial authority, fails to give reasons for such order.
The principles of natural justice, where the compliance with is mandated. Question asked by my learned colleague on bench is, seems to have an appellate for the competition. Why have you come to the Supreme Court to request the extraordinary special under Article 136 instead of pursuing the appellate? And each level of the tribunal, each level of the administrative authority is has very what is called competence power. They are competent to handle issues as well. Why did you not approach the appellate tribunal? Second, you are appearing in both the appeals as a respondent in one and the appellant in the other. One has been allowed, one has been dismissed. Yes, that approach discretionary. So, what are the contours of the discretionary jurisdiction of the Supreme Court? Is it bound by the alternative remedy? And why have you not approached the alternative remedy? For what reason? You say it's expediency because of the urgency of that. Do you have any decisions with regard to the plenitude of the discretionary power of the Supreme Court to that?
Indeed, Your Lordship. Answering the question, there is the case of the Takeshin Cotton Mills, where it states that it is not prerequisite to exhaust all the alternative remedies available to the appealant. Further, Your Lordship, the reasons that were so compelling that the company has to, as a client, bring before the case to the Supreme Court under Article 136, was there a substantial portion of law. The portion of law that is involved is the abuse of dominant power, which is of paramount importance in a competition law, Your Lordship. The Lordship, it is causing appreciable adverse effect on the competition, and when the competition is affected, not only two commercial entities that are present in the market that will be affected, but the country itself, because competition is a vital element of the growth and economy of a country. The developing country has, as per the economic theory, 50% of the economic growth depends on the kind of competition that exists in the market. And
that's the merits of your case. That's the merits of your case, right? That has a substantial economic impact on the country, society, and it also adversely impacts your economic interests. But those are the very merits which have persuaded you to go to the competition tribunal.
Indeed, Your Lordship.
The competition tribunal has the capacity and the jurisdiction and power and authority to address those questions. Not the competition appellate tribunal have that.
Indeed, Your Lordship, the
point I'm making is that seeking an ultimate remedy, instead of intermediate remedy by approach to the Supreme Court, particularly when there is violation of the Bengal military complication and all that. When approach the Supreme Court on the ground of experience and early resolution of the dispute is one factor. But don't argue the merits of the case. Because merits of the case, tribunal can do it, appellate can do it. So that is not an argument germane to the reason why you have approached the Supreme Court. That's your grievance. Understand?
Yes, sir.
So the moot court is both an adjudicatory forum as well as an advisory forum. State and lawyers are the argument. Lawyers speak. Lawyers have a priori bias. The point is that when you put forward a point, treat the court in a manner the court will think cannot come back to you. And you have to make the point, you have to make the other side point also. The merits of the case are irrelevant to your approach. The reason why you approach. But why Supreme Court are not appellate tribunal can also do it as the learned member has said on this tribunal. So, approaching the Supreme Court, you wanted a final resolution. Supreme Court does not admit of alternative remedies of which fines. But don't argue the merits of the case. Government institution, all that anybody can decide. Property the tribunal can decide. The tribunal can also do. That's the point.
Your Lordship, if we have, if we would have both NCLT and the orders would have been delayed further, like if after the NCLT had appear before the Supreme Court, it would have more stagnated the market for a longer period of time. And going to the fact that the COVID-19 has generally hit the country in that period of time, and the market was facing so many economic crises, and a company like CPCL, which is one of the major companies in providing the telecommunication as well as mobile manufacturing. There are two markets that are being operated at the same time. It's being hit, and not only in one market, but both the markets because of the order of the CPCL. The further stagnation of the market because of the order of NCLT and then and the extended period of time could definitely hamper the economic development more than approaching the Supreme Court directly. There can be a final and a period. Much obliged, Lord. If your Lordship is well versed with the if your Lordship is well versed with the arguments of the council and have no further question on antiquity, the council would like to proceed to number 3, that is issue of card liability.
But why did you raise the issue? Why can't the respondent raise that question? Or you're so moto raising a shaman and answering it?
Your Lordship, the boundaries of the moot court competition does not allow us to know the ability of like respondents appeals from first time.
You're anticipating that they raise the question of integrity and answer.
Indeed, Your Lordship, we are anticipating and we are not trying to leave any ground that petition can be dismissed.
Covering all the bits, fine.
Much obliged, Lordship. Moving forward to the third second argument of the present appeal, that is the argument regarding the cartelization. Your Lordship, section 3A and B resumes action in concert, which is a form of an agreement by a cartel. It is a form of an agreement by a cartel engaged in direct or indirect determination of sale and purchase. Secondly, limit or controls of supply in order to have appreciable adverse effect on competition. Your Lordship, the council will move forward to present that AKK and other mobile manufacturing companies were guilty of cartelization because of 4 factors. Presently, first one is that there exists an agreement between the parties. Secondly, that there were structural factors in the mobile manufacturing industries conducive for cartelization in the market. Thirdly, that there were circumstantial evidences present for an anti-competitive agreement to be established. And fourthly, that the onus of proof is on the contrary party to give away with the circumstantial evidences that are present. Your Honor, Your Lordship, moving forward to the first limb of the argument, that is, there is an agreement between the parties. The definition of the agreement includes action in concert, Lordship, and it is broadly defined and need not be a formal or written one. And when such confidential meetings are held and closed from within 4 walls, it is very difficult to prove it by a conclusive evidence. Your Lordship, in the Neeraj Malhotra case, it was stated that to establish agreement between persons with
must not be conclusive. And secondly, the business behavior is an admissible circumstance, evidence from which fact finders can infer agreement. Further, Your Lordship, in the case of sugar mills, it was stated that the proof of meeting of mind is not necessary for violation of section clause. Considering all these arguments, each of the three manufacturers post a confidential meeting offered special discount on specific models that were competitive enough to counter the chapless mobile sales. This specification, this type of particularity towards what kind of special discounts and what kind of models are to be chosen, this refers to the meeting of mind as well, Lordship.
Here. What is your prayer on this point that CCI different scale and you are filing this special petition, bypassing not one but two statutory appeals? There is first appeal before the appellate tribunal, that is LCA. Second statutory appeal, regular appeal, not SLP, you have come. Now, under CCI Competition Act, there is a procedure. Cartelization is first investigated by a director. So, even in the best case scenario, if you were to persuade this bench, what is the prayer? You are going into the cartels on the merits. So, are you expecting a finding of cartel and a finding of contravention and imposition of penalty? Then we will conduct investigation. Now, do you expect us now not only to substitute ourselves for CCI, but also now substitute for the Director General, to whom CCI, after forming a prima facie opinion, they send the matter for investigation. Without investigation, even CCI cannot pass. So, what is your prayer on this point? What do you want?
Your Lordship, the prayer on this point, that proceeding concerning case number 42 of 2001, that was regarding cartelization, should be remanded back to CCI to pass an order afresh with the reasons to be cited. This time, the reasons should be expressly mentioned so that the reasons can be challenged before the appellate tribunal on the basis of merit. Because the merit was missing, the appeal could not have been provided.
That is what I was coming to. If the only remand you are asking for that there is no reason, then why to go to the enter into the merits whether there was agreement or not? That is the only point I wanted to understand for myself.
Indeed, Your Lordship, the Lordship reason behind getting into whether the cartelization existed or not is to present before the Lordship the view that these were the factors that were present and the cartelization was there, and dismissing of appeal without giving a party to the hearing, the right to hearing. CPLC was not heard, it was dismissed. And though cartelization was present at that point of time, it was a blatant fault on the part of CCI. It is just to persuade the court more into the fact that our prayer exists on a point that should be provided to us.
Look, it's an advice to all the council, young councillors. There's a difference between an academic engagement and engagement in the court. Have you seen Enter the Dragon movie?
Apologies, Your Lordship.
Bruce Lee, famous Enter the Dragon. So Bruce Lee is a big martial arts master, maestro. So young fellow wants to join him. So he wants to impress the master so that he can join the school. So he breaks 15 bricks. So Bruce Lee says bricks don't hit back. So in the courts, the other side is hitting you, the judge is also hitting. That's the difference between a live engagement and a mock engagement. It's like playing ball tennis, real tennis. Now the question that the court has asked you is that what is it that you want? Rightly reveal you want a remand because the Supreme Court in a SLP, not in a statutory appeal, is the appellate authority, and then Supreme Court is a feature of the statute there. It's not a Supreme Court consulting Supreme Court. So we can't conduct the investigation. Whereas in an appeal, the Supreme Court can directly direct out investigation to conduct an appeal to statutory appeal. That's the difference. Therefore, when that question is asked, you say, sir, I want to appeal to the state report that there are sufficient documentary material to show prima facie that there is element of cartelization and anti-competition issues presented here, which ought to have been decided by the tribunal on the first instance, the primary tribunal, which are paid to do. Therefore, I want you only to demand, I don't want you to sue or to make ratification of facts. That is how you have to meet the war as it emerges.
Indeed, Your Lordship.
In a war, what happens is India is going to war against Maldives also. Prepare a contingency plan in case of defeat, where should I surrender? You're never very sure. Prepare yourself for a dynamic situation when you're arguing in a court. Thank you very much. You have done well.
Should the council proceed? Much of that, Your Lordship. Your Lordship, there are structural factors, that is the second leg of the argument, for which the mobile manufacturing industry becomes conducive for cartelization. Your Lordship, these factors are the, firstly, Your Lordship, the council would like to establish that it is an oligopolistic market that we are dealing with right now. There are only 4 firms holding 97% of the share in the market. Your Lordship, in the case of LPG, it was stated that when the product and services offered by the market is similar, it's easier for them to come into a common consensus regarding the sale and discussion of the prices. Your Lordship. Your Lordship, the factors that are present currently here are the inelasticity of demand, high concentration of market share, and homogeneity of product. Dealing with the inelasticity of demand, Your Lordship, it means that the prices when increase or decrease does not affect the demand of the product in the market. Your Lordship, mobile phone being a modern necessity, and the lack of substitute for a mobile phone still exists in the market makes it conducive for inelasticity of demand. Secondly, Your Lordship, there is a high concentration of market share, as has been already stated by the council, that 4 players are entirely holding 97% of the market. Thirdly, Your Lordship, the product in question is a homogeneous product. Mobile phones in features, functionality, and the raw materials that are being used in their manufacture are one and the same. Moving forward to the issue of with the limb of argument that circumstantial evidence that may be established, Your Lordship, the market. Apologies, Your Lordship. Your Lordship, the circumstantial evidences may establish an anti-competitive element for the concerning markets and the conduct of the participants as well. In the tire cartelization case, the Supreme Court held that parallel behavior accompanied by factors indicating coordinated behavior can form an issue for cartelization. Your Lordship, these are called the plus factors. The present case, the plus factors that exist are exchange of sensitive information among the competitors. Your Lordship, especially the data linked with competitive conditions that are in respect of the prices as well as the discount. Your Lordship, in the instant case, information was exchanged regarding price of the product as well as the specifications of the product. The product was specifically competitive enough to counter chapless mobiles. Your Lordship, parallelism was observed in both the things, prices, that is a special discount, as well as the product, the competitive ones. Secondly, Your Lordship, there were high profits ensued. The collusion in market or the cartelization generally occurs when the parties intend to gain high profits out of the agreement that they enter into. In the present case, the facts state that not only the offers presented by these companies impacted the sale of chapless mobiles, but they also gain high profits out of these things. Moving further, last limb of the argument, that is the onus of proof should be on the contraventing parties to tackle the circumstantial evidence, Your Lordship. Your Lordship, the court has developed 2 rules for stating the onus in the present cases of competition, that is rule of reason as well as the per se. The Raghavan Committee has stated brought into action the rule of reason in India, but it has also stated in its report certain agreements that are per se anti-competitive. And quoting the report, Your Lordship, item A of the list states that, and I quote, agreements regarding prices, that is, agreements directly or indirectly fixing purchase or sale price, are per se anti-competitive. Your Lordship, in the Story Transports case, as Supreme Court also held that the onus lies on the opposite party to prove that there has been no violation or anti-competitive agreement in place. If
if your lordship is satisfied with the argument, just want to verify one thing, that there is no per se illegality. Not a single agreement has been declared per se anti-competitive or illegal under the Competition Act. We have not followed this per se approach at all. All it says is in certain category of cases, horizontal agreements, that is cartels and the people in the same trade. Now, there is a presumption of appreciable adverse effect on competition, which is a rebuttable presumption. So the presumption is about appreciable adverse effect on competition. Not that these agreements have been per se declared unlawful. It is a very advanced thing which we have adopted in between per se and rule of reason. So partly, yes, in which we are able to demonstrate that people in the same trade, they have engaged in this conduct, then there shall be a presumption. Now it is for the telecom players to do it.
Indeed, your lordship, owing to this certain information, we use the word like onus is on the certain party to prove, and certainly we use the word anti-competitive per se instead of illegal. So the
word postulates and the word shifts, and there is a prima facie showing of a particular basic inference. So the agreement raises an assumption of anti-competition. And therefore, word shifts. That's how we should put it. Clearly saying that it's also argued the matter of strategy. You are affected, we care a dam, country cares a dam. So state also affects the country, society, consumer. Consumer is taken for a ride by the cartelization. So also hit that emotional portion of the text.
Indeed, your lordship, as the
Solvent sports time.
Indeed, your lordship, as the council has already stated that country faced the economic crisis and that the market was running into
Thank you.
crisis. Much of that, your lordship. My co-councils have been dealing with the next report. Much of that, your lordship. It was pleasure.
Greetings, Your Lordship. Council number 2, appearing on behalf of the appellant, not violate each code of the competition. In this regard, Your Lordship, divided in arguments into 3. First, shall be daily making to relevant content under the second question, not dominating the relevant market. Third, dominant in the different market. Don't include the dominant. Argument concerning information of use of dominance to quintessential identify the relevant product market. One, that the telecom job in the market is the state of industry because the telecom service provided by CPA is uniform pan-Asian. And second solution is that the relevant product in the market of telecom services, considering the nature of interchangeability of telecom service provided, various players present in the market. Next step of the argument that CPA is not dominant in the relevant. In this case, the argument is one, that the market share in the is not an indicator of dominance. That CPLC has not satisfied the multitude of requirements enumerated under Section 19, Subsection 4 of the Act. As far as market share is concerned, in the institution, this CPLC being 50%. Not a dominant entity because of 3 pillars of arguments that I'll be arguing. One, that market share is not a conclusive proof of dominance in the market, as was here in the case of Ramakant Kini versus Dr. L.H. Hiranandani. Moreover, it was held in the case of Fast Track Polygraph acknowledges that market strength is a relative quantity. To assess the strength of an enterprise in terms of its market share, it is a paramount importance to also consider its competitive market share to reach a meaningful quantity. Your Lordship, in the instant case, that operated in 40% of the market and was the second largest telecom service provider. Therefore, the logical inference that can be drawn is that that was the largest telecom service provider and operated in the market share. Even after the merger, this first by largest telecom service provider continues to be an entrenched player in the market with a sustained business value. Now, in the presence of such an arc rival, CPLC cannot be said to be dominant in the relevant market. Second pillar of my argument is market share analysis is not suitable to determine the dominance of an enterprise in a dynamically competitive market. Because here is the case of Krishna Chadha versus Watson. Certainly a dynamically competitive market because the market shares are moving substantially in a very short period of time. Thus, market share in such a market is not a true indicator of market. Now, the third pillar of my argument is that for a player to have a dominant position in the relevant market, it should hold down market share for a reasonable period of time. Fluctuation in market share happened over a very short period of time. Therefore, market share should not be considered to be an indicator of CPLC's dominance. My argument is assuming, not accepting, that CPLC is dominant in the relevant market. Nonetheless, CPLC has not abused its dominance in the relevant market because firstly, CPLC has not imposed predatory pricing. And secondly, CPLC has not abused its dominant position in one relevant market to enter into another area. Your Lordship, moving to the first submission that CPLC has not imposed predatory pricing. Your Lordship, based on the scheme that was announced by DPA, model. Not from services of telecom service provider. It always put its number to another telecom service provider. Further, Your Honor, the mobile manufacturing market is highly competitive. Thus, a potential mobile phone purchase is not in any way likely to purchase Chapless mobile phone in comparison to any other mobile phone that is available at a very competitive price in the market. Thus, all these facts bring home the point that predatory intent cannot be attributed to CPLC. Now, the second submission is that CPLC is not used its dominance in one relevant market to enter into another relevant. In the instance, CPLC does operate in two markets.
You are saying it is not predatory. Your market share is in the 65% of the user base. 65%. And you are admitting that you announced free services for 18 months. Now, 18 months, if you provide free services, which player in the market would be able to survive? If predatory pricing is below cost. Now, here it is a case of zero price. So I don't think we need to go into the aspect what was the cost and whether it was below cost, above cost, and what was the margin. It is a clear case of zero pricing. I can understand customer acquisition, you offer a freebies for 30 days 45 days or something like that. 18 months, it is an economic annihilation. There is nothing like a free lunch. In the 70s, these multinational cold drink companies came, Coca-Cola, they were all sold free of cost. And ultimately, today you have a duopoly of these two multinationals, Coke and Pepsi. I'm very open about it. So, free lunch is a myth, particularly in the economic sphere when you are dealing with economic agents. 18 months you are providing free lunch. Something I'm not very sure, but predatory, you say it is not, I'm not very sure. You say I'm not dominant. With 65% of user base, if you are not dominant, which is, I would say it's a very super dominant position. And then you say this is not the only factor, I agree. The market share alone is not a factor if the entry barriers are not there in the market. Now, to enter into a telecom market where a lot of investment is required for infrastructure, it is not just in the air. There are towers, there are fibers, a lot of last mile connectivity, the right of way, right of access. So difficult. So entry also I do not foresee so easy. So if you are saying market share is not decisive, let's go into the other aspects. The other aspect can be the financial resources of myself and of my competitors. You have 65% user base. Your next competitor, what is his user base? What is your financial muscle? What is your next competitor's financial muscle? All these factors, just saying this is not, I agree in principle, I fully agree. Market share is a static tool, is not decisive of dominance in the market. But then we must find out what are then the relevant factors, other relevant factors, and then apply those standards. Because ultimately, after 18 months, when all other economic agents are finished, and you start recouping all your free lunches, we have to consider.
You also mentioned the periodicity of the dominance. That's a principle. So, what period is reasonable and what period falls into predatory and anti-competitive, attributes?
You're also, that is something that's
Variable according to circumstances.
Yes.
So when you say that only for a short period, be stabbing somebody with a penknife, die over a period of time, you can shoot him with a bullet, very short. So the periodicity of dominance is not a rule, it's a principle. So how do you answer?
Leadership, it was categorically held in the case of fast rate Polcap versus Danish technology that for an enterprise to be declared dominant in the relevant market, it should be able to hold its market share for a reasonable period. The market share. After the merger, it ended up having 55% of market share. Launch ended up having 65%. So the change in market share is happening for a very, very short period. Therefore, it should not be held to be an indicator of dominance. Concern about entry barriers. Fast requirements enter into a sector. It cannot consider entry barriers. So, finance. There is no evidence whatsoever that there is no leverage in terms of the finance. Therefore, to say that merely because high capital requirement is needed to enter into a sector cannot be held to be an entry. Moreover, Your Honor, which market share is to be considered to determine whether the enterprise is dominant? To answer that, it is alleged that CPS is abusing its dominance. This dominance is being abused by the announcement of the zero pricing scheme. market share CPC knows uh,
say if there is a market structure is diffused. Now we know various companies, promoters with 5% holding, they control the company. So therefore, if the market is diffused, there are small players as you are saying, 14, 15, this is not a small sum.
Your Honor, as is evident from the fact that before mergers, it operated 40% of the market and second largest telecom service provider. Therefore, there existed a company that was the largest telecom service provider and operated in more than 40% of the market share. So even if market share of is close to 55%, first the largest telecom service provider continued to be an entrenched player in market share and heavily influence consumer base.
The merger was a defensive strategy rather than a predatory strategy.
Indeed, Your Honor, it was a strategy.
Merge to survive and compete against the dominant player because you are number two. Want to become at least on par with number one. And that's why you merged instead of trying to kill number one.
Your Honor, the merger was with the intent to flourish in the market and merely because the enterprise is dominant, it is not something that is wrong under the competition. Even the dominance in a relevant market is not wrong under the competition act. Abuse of dominance is a problematic thing. So, and as I have already said, CPLC was not even dominant, let alone abusing its dominance. If the lordship may permit, can I proceed with my argument? Now, moving with the second limb of my submission, that CPLC has not abused its dominance in one relevant market, entered into another relevant market. In the instant case, Your Honor, CPLC does operate in two relevant markets, namely the market of telecom services and the market of mobile money. Having said that, CPLC has no actual contravention of Section 4 to E because CPLC is not dominant in the market of telecoms. However, assuming that CPLC is dominant, do not accepting this convention. Assuming that CPLC is dominant in the market of telecoms, cannot be said to have violated Section 4 to E. This is because the mobile manufacturing market is a established market with renowned players competing vigorously against it, which is evident that when the other players in the market decided to offer special discount on their products, which are more competitive as compared to chapter smartphone, the decision remained effective and adversely affected the sale of chapter smartphone. This is clear indicative of the fact that just because of opening, purchases of mobile phones were not getting more than purchase. Moreover, purchases avail the services of CPLC buying chapter smartphone is not at all. Therefore, it is contended that CPLC is not acted in violation of Section 4. If the lordship is convinced with the arguments, the council seeks permission to proceed with the prayer.
I give you a declaration, we are convinced. But we cannot. You have completed your argument, but you move on to your next point.
Lordship,
You are done with the prayer? All right, thank you.
Lordship, the prayer has not yet been decided. Therefore, in the light of issues raised, arguments advanced in the authority cited, it is humbly prayed that this honorable court may be pleased to adjudge and declare the impugned common order dated 15 November 2021 passed by CCI insofar as it allowed case number 23 of 2021 is bad in law and be struck down, and the proceedings concerning case number 42 of 2021 be remanded to CCI to pass order afresh with reasons therefor, and pass any other order that the honorable court may deem it in the interest of justice in good conscience. and for that the council shall determine the fee of life. For the special agreement before the
Permission of the lordships to the council. Much of that is not. Greetings to the bench. Great please this honorable court, where the councils on behalf of respondent in special petition number 21 of 2022 in the matter of Bombay Company Private Limited versus the Competition Commission of Petition. The council seeks permission to address the bench collectively and the lordships. Much obliged, your lordships. If the lordships are well versed with the facts of the case, the council seeks permission to proceed straight to the arguments. Much obliged, your lordships. We shall bring forth 3 submissions before this honorable court today. Respondents, Competition Commission on Petition.
You are representing CCA
Indeed, your lordship.
and there is no other respondent.
Your lordships, the parties to the parties which were opposite to CPLC in the combined order, which was given on 15th November 2022, have not been made a party to this case by CPLC. Can I proceed? Much obliged, your lordships. We shall bring forth 3 submissions before this honorable court today. The first one being that the present special leave petition before this honorable court is not maintainable. The second, that the conduct of CPLC is in contravention to section 42A2 and section 42E of the Competition Act 2002. And thirdly, that AKK Mobile Limited, BBNR Centec Private Limited, and ADS Techline Private Limited have not violated section 3.1 and section 3.3 of the Competition Act. I will present the first and second submission, for which I shall take 15 minutes of this court's time, and my co-counsel will present the third submission, for which she will take 10 minutes of this court's time. If the lordships are with me, the council seeks permission to proceed with the arguments. Much obliged, your lordships. Your lordships, the first submission on behalf of the respondent today is that the present special leave petition before this honorable court is not maintained. The premise of the submission is twofold. That firstly, that petitioners have not exhausted the alternative efficacious statutory remedy available to them, and secondly, that the special and exceptional circumstances, as has been mandated by this court through various judgments, are not present in the special case for application of Article 136. The first step of the argument, your lordships, is that the special leave petition should not be allowed by this court, since the petitioners have not exhausted their statutory alternative remedies present under the Competition Act before invoking the extraordinary jurisdiction of this court under Article 136. The present submission has 2 limbs. Firstly, that alternate and efficacious statutory remedy is available, and secondly, that the exceptions laid down by this court for the factors laid down by this court for exception to this doctrine are not applicable in the present. Your lordships, the first submission is that the doctrine of exhaustion of alternative remedies guides the practice and procedure of this court in application of Article 136. As per the principle laid down in the case of British India Steam Navigation Company versus Jagjit Singh, it was held that all statutory remedies would have to be exhausted before approaching the SC under its special jurisdiction. Furthermore, your lordships, it was stated that contrary to that, can be done only when special circumstances can be shown by the petitioner to exist in the present case, which the petitioners have failed to show. Furthermore, it is submitted that the council seeks to bring to the notice of this court that the petitioners have effective statutory alternative remedies given under section 53A, E and D of the Competition. Your Lordship. Your Lordship, what the council is getting to is the fact that the jurisdiction under Article 136 of the Constitution of India has been held by this court to be exercised very sparingly, and in cases where special question of law can be shown to exist, and not merely when a finding of fact has been challenged by the petitioner's Lordship. The council seeks your Lordship's kind attention to flag number.
Now, they are saying you have not given any reasons. So I am not very sure of your submission that you don't, as a regulator, firstly forget about maintainability. We have doubts about your own this standing before the Supreme Court. You are a adjudicator, and you are not a party in that case. You are, of course, you have chosen to defend your ruling, being an adjudicator, a quasi-judicial authority. Be that as it may, as I understand, you are at best a proper party, not a necessary party. This is what the Honorable Supreme Court has said in the Steel Authority of India case. So, SLP maintainability is not an issue. This court has dealt with granted anticipatory bails under 136 bail, no problem on that point. The issue is of a fit case, whether it is a fit case for exercise of this extraordinary jurisdiction. So, maintainability part is a constitutional power, sky-high power, except the self-imposed limitation, which is guided by precedents. So, that is the only limited point, that whether that threshold is met in this case or not. Now, here they are saying you have not given any reasons while dismissing the case. So, what you have to say on this aspect, that there are no reasons, but you will argue that this is not the proper forum. Where the citizens.
Your Lordships, the council acknowledges our kind concern, but would like to draw your attention to flag number 2 of the compendium, Your Lordships, which is the clarifications. Lordships, I seek your kind attention to clarification number 30 of the clarification number 13, flag number 2. The council on behalf of respondents have gone on and on about how reasons were not given in this judgment. Wherein in clarification number 30, it is clearly stated that strong reasoning was given based on applicable legal principles by considering facts of this case. Clarification number 30, in flag number 2 of the compendium. Your Lordships, it is given that when it was asked that what were the reasons of dismissal of case number 42, it was given that please be clarified that the reasoning was strongly based on applicable legal principles after considering facts of the case. Your Lordships, it can be seen that the counsels on behalf of petitioners have misled this court by stating that reasons were not given to them for dismissal of the case under Article 40, case number 42. Your Lordships. Furthermore, Your Lordships, I seek your kind attention to flag number 6 of the compendium. This is the landmark judgment of Preetham Singh versus State, which guides the practice and procedure of this court under Article 136. Your Lordships. In the last page of the judgment, Your Lordships, the highlighted part, I'll read for the Lordships, said that it seems clear that the wide discretionary power with which this court is invested. Your Lordships, para number 11. The second last page of the judgment in the highlighted part of the Lordships. It seems clear that the wide discretionary power with which this court is invested under is to be exercised sparingly and in exceptional cases only, as far as possible, a more or less standard should be adopted. It is further stated that, in our opinion, the next highlighted part of the Lordships, it is stated that, in our opinion, the standard that can be laid down in circumstances is that this court should grant special leave to appeal only in those cases where special circumstances can be shown to exist. Your Lordships. Here, as contended by the counsel on behalf of petitioner, reasoning was not given. The same is countered through clarification number 30. Your Lordship. And furthermore, it is submitted that in this case also the special leave petition was dismissed. Furthermore, Your Lordships, in the very recent judgment of Allahabad High Court, which was in the case of Vinayak Trading Company versus
both the Supreme Court and one side High Court judgment. At least the discipline went.
in Your Lordship, what the council was getting to.
Allahabad High Court can give any help about the cases in which we should exercise our special jurisdiction. I agree with what you want to argue on this point.
Sincere apologies, Your Lordship. What the council was getting to is that the standard before this court for application of Article 1. Sincere apologies, Your Lordships. The council seeks permission to move on to the next limit, Your Lordships. The next limit is that the exceptions laid down to Article 136 in the case of Radha Krishna Industries versus State of HP are not being met in the present case, Your Lordships. Your Lordships, in this case, there were three principles that were laid down for application of Article 136. Firstly, that the writ petition must have been filed for the application. That the petition must have been filed for the application of for the enforcement of a fundamental right protected by the Part 3 of Constitution. Your Lordships, it is humbly submitted that the petitioners have not contended the violation of any fundamental right in the case. Furthermore, it is submitted that there has to be a violation of principles of natural justice. Your Lordships. The petitioners have failed to establish any violation of principles of natural justice because reasons were also given. They were heard and orders have been passed, which have been given to them.
They argued, if I have not heard incorrectly, they said that no reasons, no hearing. And you said they were heard. So please clarify about hearing, whether CCI granted hearing or not.
Your Lordships, combined order has been passed in the given case, and the fact sheet is completely silent on the procedural aspect of it.
So there is no clarification. There is no point of clarification on this area part because this is very fundamental. There is no hearing, then I think it's a very different scenario.
Indeed, Your Lordships, the council acknowledges the kind concern, but would like to state that when the petitioners state that there has been no hearing which is given to them, that is another blatant assumption of facts based on the fact sheet. Furthermore, Your Lordships, the council seeks your permission to proceed to the second argument. The second argument, my next submission is that bench is very as to what is your standing to for this special meeting. You are a tribunal. How are you agreeing? Yeah, Your Lordships, we are not the aggrieved party. It is CPLC that has approached this honorable court by way of SMP under Article 1. Why tribunal approaching? You are representing the tribunal article. What is your grievance? The order is set aside, it's set aside. There will be no recovery of your salary. Pardon, Your Lordships. There will be no recovery of your salary as members of the tribunal. That is what the council is stating, Your Lordships. That is what the council is stating, Your Lordships. Just say I'm a tribunal. Do whatever you want. Don't play a kind. I'm not a competent. I'm an umpire, Your Lordships. That is what the council is getting to. That. Your Lordships, that is what the council is getting to. That in the given case, the application of Article 136 is not warranted, since the questions that have been challenged by the petitioners could have been very well dealt by the tribunal. Never decision making authority, primary tribunal or appellate tribunal, never enter into the fray beyond the fray. Judicial practice, given that the order is set aside for whatever reason, there is no recovery of salary. Otherwise, there is good class orders, as is the art. So, tribunals approach only when there is a structural damage, not on merits.
It should not become a partisan in the litigation arena. Of course, if there is a decision which impacts your functioning, jurisdiction, and in some cases, otherwise you can provide assistance. But so I remember a ruling of the Supreme Court in 2010 when CCI started functioning. They said that it is inquisitorial, not an adversarial. So therefore, in an inquisitorial setup, anybody can highlight information. It is not complaining, it is informative for CCI. So there, of course, they laid out that higher responsibility there in such a setting, because informant may not come forward. So ultimately to assist. So even if then you should be say that you are assisting and not as if on a preliminary grounds, conduct, this, that, everything. We are assisting, and that is very welcome, and we are grateful for that.
What the council submits here is that when the petitioners approach this honorable court under Article 136 for against the CCI order, the very mechanism that is set by the legislation of Competition Act 2002 to protect this to save the application of Competition Act by way of giving Chapter 8 of the Competition Act a launch, where there is a clear mechanism of appeal which is present. Under Section 53A, the parties can approach the National Company Law Appellate Tribunal. Furthermore, under Section 53T, your lordship, this honorable court can be referred to against the order of the embassy, your lordship. That is when the remedy before this court arises, and not in the present case when there is no substantial question of law, but the question is whether the application of Section 3 and 4 has been correctly done by the CCI or not. And the same has been vested in NCLAT under Section 53A of Competition Act. As a tribunal, court of discretion, the jurisdiction of discretion like 130, or a scientific appeal. Sometimes also saying that it's the special law in the interest of the economy and the consumer, and therefore speedy disposal is of the essence. And therefore, determinant appeals, delay the process of ultimate implementation. Therefore, we have to prove it to that extent. What to do on your merits is your headache. That's how you should approach. If you should argue on merits as well as defending your action, you become a party in the fray. So, a tribunal approach to the court of review or court of appeal has a very limited scope. Should not enter the battle because the adverse comments were made against you. Yes. So that the guidance for courts to approach the appellate. Much of that, your lordships. This brings me to my next argument, your lordship. That's the violation, the application of Section 3 and Section 4 is correct. My next submission is that CPLC has abused its dominant position in the relevant market by way of predatory pricing, and therefore is in contravention to Section 42A2 and Section 42E of the Competition Act. It is humbly submitted that the premise of the argument is threefold. That firstly, the relevant market being proposed by the council on behalf of petitioners is erroneous. Secondly, that CPLC is dominant in the said relevant market, and thirdly, that CPLC has abused the said dominance. Firstly, the delineation of relevant market in such a case where the entity is operating in two different markets, should be on the basis of an upward market and a downward market. The relevant market has to be ascertained in both the relevant markets. It is submitted that it is clear from the explanation of Section 4 of the Competition Act that it is necessary to first determine relevant market in which a particular entity is alleged to be in a dominant position. This requires delineation into relevant product market and relevant geographic market. In this given case, the relevant geographic market, keeping in mind the homogeneity of conditions provided in Section 19(6) of the Competition Act, suggests that the relevant product market in this case happens to be the country of English. Furthermore, the relevant product market in the given case, as can be seen in the given case, the relevant product market here has to be considered to be the upward market in which the CPLC is in the business of mobile manufacturing, and the downward market where CPLC is in the business of telecom. Therefore, it is submitted that the relevant market which has to be delineated in the present case is the upward market of mobile manufacturing and the downward market of telecommunication services technology in the country of English. The second limb of the argument is that CPLC is dominant in the said relevant market. Dominance, according to Section 4, means a position of strength that enables the enterprise to operate independently of the competitive forces that affect the consumers in its favor. So, Lordship, Section 19(4) of the Act provides a list of factors that have to be considered while considering dominance. The council on behalf of petitioners have continuously argued that the market share of the company should not be the criteria to evaluate dominance in the present case. Lordship, it is humbly submitted that the market position of CPLC does satisfy the other factors which are given in section 19 for your Lordship. Moving further, it is submitted that in the case of Hoffman Laroche versus the Commission of European Committee, it was held that market share and size of the firm is a significant factor reflecting dominance. Your Lordship, furthermore, it is pertinent here to highlight that the competition jurisprudence of Section 4 of Competition Act has been derived from Section 1, Article 102 of PLT, Your Lordship. At this stage, relied on Article 102 of PLT. Furthermore, Your Lordships, it is said that CPLC has the highest market share in both the upward market and the downward market, which are the market for mobile manufacturing, where it controls 49%, and the market for telecommunication services, where it controls 65%. Furthermore, it is submitted that substantial entry barriers is another factor that is given in section 19(4). Your Lordships, barriers to entry play an important role in determining dominance of an enterprise, as it ensures that the enterprise is able to maintain a position of strength by foreclosing the market. Your Lordships, it is submitted that in the present case there are substantial entry barriers, as the telecommunication industry has very high capital requirements and big financial risks. Your Lordships, counsel on behalf of petitioners have argued that access to financial resources have to be considered by determining that whether financial resources of competence can be considered to be relevant factors or not. It is to bring the council brings to the kind notice of this court that while during the establishment of Jio by Reliance Enterprises, $14 billion had to be spent before Jio came into existence in 2000. It is to be noted that the amount of entities who have access to $14 billion to create a new telecom company is very limited. Furthermore, the Lordship, it is submitted that the price of spectrum which the company has to buy at a relevant period for all 22 telecom sectors of this country independently, your Lordships, that goes up to 693 crores per megahertz in the relevant 1800 megahertz spectrum, which is used in the 4G network, your Lordships. Therefore, it is submitted that in the present case, the entry barriers are very high, and therefore the foreclosure being done in the market by the actions of CPLC are very evidently shown. Furthermore, the Lordships, the next factor given in section 19(4), which has to be highlighted here, is that there is negligible countervailing buying power in the market, your Lordships. It is submitted that buying power is one of the essential factors that has to be looked at while assessing the dominance of an entity. Presence of countervailing buying power in the market offsets the power of seller enterprises to indulge in anti-competitive behavior. Lordships, in the present case, CPLC holds a market share of 65% in the telecommunication sector, means that all other entities comprise mere 35% of the market. The Lordships are with me. I would like to bring to the notice of the Lordship that the council on behalf of petitioners have themselves highlighted how CPLC has removed the entity which was at #1 position where the CPLC held 40% market share, and now that entity is one of the various entities that would combined hold mere 35% market share due to the actions of CPLC. This clearly shows the foreclosure being done in the market by CPLC. Furthermore, it is submitted that when entities like the entity which used to hold #1 position in the market, which has not been named in the fact sheet, or Lordships, when such entities can be affected by the actions of CPLC, it can be clearly seen that the countervailing buying power, remaining 35% countervailing buying power, will soon be eliminated by the actions of CPLC. Furthermore, the Lordships, the council also seeks our attention to the fact that the offer that has been given by CPLC for 18 months is not a time-barred offer, the Lordships. It is stated that the offer will begin from 1st September, but it has not been stated that the offer will last only for 18 months. It is with the purchase of the CPLC smartphone. Therefore,
for passing order, did you consult TRAI?
Your Lordships, in section 14 of TRAI Act, it is clearly stated that anti-competitive
did you consult or not?
Your Lordships, the concern here was the abuse of dominance, and section 14 clearly states that
Supreme Court has said in Bharatiya Television that if the issue is before also the sectoral regulator, then in the first instance, the jurisdictional fact should be fleshed out by the sectoral regulator, and then the CCI can proceed from that. So, did you consult the sectoral regulator at all?
Your Lordship, somebody submitted before this honorable court that section 11 of the TRAI Act clearly excludes this matter from the jurisdiction of TRAI. Your Lordship. TRAI can only handle, TRAI can adjudicate with respect to
Section excludes TRAI specifically, you said.
the section 14, Your Lordship. I shall read for Your Lordship. Section 14, provided to section 14 part A, Your Lordship, reads that
Competition
TRAI Act. TRAI Act states that monopolistic trade practice, restrictive trade practice, and unfair trade practice, which are subject to jurisdiction of MRTP Act, are excluded from the jurisdiction.
MRTP Act now.
Not the Act now.
That is not the Act.
Your Lordship, I have to stop this. Indeed, Your Lordship, Council acknowledges the fact concern. I would like to state that the Competition Act is in development of.
I am not saying they can look into monopolies. They can look at the jurisdictional facts. If they are involved. So there is a Supreme Court ruling. Of course, competition CCI will do.
Furthermore, I would like to bring to the kind notice of the Lordship the fact that the powers of TRAI are limited to telecom operators, and when the dispute is between either two telecom operators or between a telecom operator and a group of consumers. The dispute here is not between telecom operators. The dispute is of pricing, unfair pricing by an entity. This has to be led by CCI. This has to be adjudicated by CCI.
Characters of disputants is different from the character of the dispute. The disputants are telecom operators. The dispute is about pricing. So they are not congruent propositions.
What the council is getting to is that under section 12 of the TRAI Act, the matter of pricing by a company for a very small section of people has been excluded from the TRAI. Keeping in mind the paucity of time, Your Lordships are satisfied with the argument on the abuse of on the presence of dominance on part of CPLC. Council seeks permission to proceed to the abuse of the same. Proceed. Much of time, Your Lordship.
Assume that we are satisfied and that we are not satisfied.
I say they are convinced or not convinced, the council will hold it on that. They are also constrained.
Thank you, Lordship. The third lip of the argument, considering the contravention of section 4 of the Competition Act, Your Lordship, is that CPLC has abused its dominance in the said relevant market. Your Lordship, as held by the 2010 CCI order in the case of Jupiter Gaming Solutions Private Limited versus the government of Goa, it was held that dominance is not illegal per se, but abuse of the same is prohibited. Your Lordship, this is further evident from section 4.2 of the Competition Act. Your Lordship. It was also propounded by the European Union Court in the case of Euro Enlarged Corporation versus Continental Can Company. It is submitted that when considering the act of predatory pricing, the three-pronged test laid down in Hoffman Laros is considered, Your Lordship, for predatory pricing. The three prongs happen to be the below cost production, the pricing below cost of production, second, the predatory intent of the entity, and third, that recoupment is there. Furthermore, Your Lordship, proceeding with the first step of the argument, it was held in the landmark judgment of Aberdeen Journal versus Office of Fair Trading. It was laid down that the very essence of pricing of a product would be predatory if it is below an appropriate measure of cost. Since there are some unavoidable fixed and recurring costs of every industry, Your Lordship, zero pricing is clearly below cost. Furthermore, Your Lordship, in the present case, CPLC is providing its telecommunication services for free without being compensated for it. Therefore, by charging zero prices for its telecommunication services, CPLC would not be able to cover such costs only by revenue from the second market in which they operate, Your Lordship, which is also illegal, which shall be apprised by the council before this court in the next argument, Your Lordship. It is said that there is a case of zero cost pricing, Your Lordship. Furthermore, the second argument is that there has been predatory intent in the given case, Your Lordship. The council on behalf of petitioners have also argued that people will not buy the product merely because the price is too low, Your Lordship. It can be clearly seen that when Jio introduced free telecommunication services, it started from zero, and if the TRAI report from January 2023 is referred, the combined market share of Jio with respect to wireless and wireless subscribers happened to be 52%. It is in a virtually monopolistic control of the market.
You say consumers will choose and decide. Did you conduct any empirical study to ascertain what consumers want? Now, you must have issued a seat and desist order that you don't do predation and all. So as a result, prices may be going up now. So what is consumer concern? Now, of course, and it is short term, I agree, and with that long term thing all are dead. But the point is, as a result of your intervention, I am afraid the prices in the market may go up. They will stop the 18 months period, which will be good enough for our population and different stages of their own income level.
Your Lordship, the council acknowledges the fact concern, but would like to make it clear and state that the very intention of the Competition Act is to prevent an entity from gaining a virtually monopolistic control of the market, which is very harmful for the consumers, because the service might be offered at a reasonable price today, but it won't be offered at a reasonable price tomorrow if the entity is allowed to proceed with the same product. Your Lordship, proceeding with the last argument, I seek an extension of 1 minute to wrap up. Much obliged, Your Lordship. The council on behalf of respondents submit lastly that there is recoupment of losses and there is future possibility of recoupment of losses in the present case. In the case of MCX Stock Exchange versus the National Stock Exchange, it was held that pricing below cost would be predatory if dominant player can successfully recoup the losses. Losses are not mandated but to be recouped from the relevant market in which the entity is operating mostly. If the relevant market is leveraging its, if the entity is leveraging its power in one relevant market to reduce sales in the second relevant market, then recoupment can be said to be done in the second relevant market also, because that is the case of MCX Stock Exchange versus National Stock Exchange. As it is evident by that
case was also zero pricing. MCX case, which you are referring to, there also the NSE offered in the derivatives market zero price, and they were
that is what the council is getting. Zero pricing is wrong when it can be shown that predatory intent is there and there is recoupment of losses. Council on behalf of petitioners may argue that the recoupment cannot be done in the same relevant market of the ground of mobile number portability, which also happens to be a fallacious argument. The Lordship has people voting in a country where there are more than 1 billion telecom service providers, and it can be shown that only around less than 10 million subscribers can vote in a month with the present infrastructure that is available with TRAI. It is not possible for the consumers to vote in manner in which the council on behalf of petitioners are contending. Therefore, recoupment is present today. It's being done today when they have reduced the sales in the mobile manufacturing market by giving free telecom services, and is possible in future because the argument of mobile number portability is fallacious. Thank you. If the Lordships are satisfied with my submissions, I would invite my co-counsel to present the submission. It was an honor argument.
dress code is only for the lead counsel. The time I've seen in both the team, only the lead counsel wears the tie. So if it is your thing, otherwise you are not properly dressed and must tie.
Your Lordships, as per the rules for the present competition, separate dress code was laid down as per genders. It was not the tie was not mandated for female counsellors in the present case. This the court considers this inappropriate. The council sincerely apologizes. The council seeks permission. Greetings to the bench. The council in the present case will be dealing with the third issue from the side of respondents. The third issue in the present case is, Your Lordships, whether ATK Movie Limited, BVNR Celtic Private Limited, ADS Tech Life Private Limited and others have not contravened Section 3(1) and Section 3(3) of the Competition Act. Your Lordship, firstly, the Council contends that the grounds of petitioners for challenging the order in case 42, that is the case of cartelization, are not present. Your Lordship, the Council for the respondent has misled this honorable court, as pointed out by my co-counsel, in insisting that sound reasons were not provided to conclude the non-existence of cartels in the present case. To show the same, the Council seeks your Lordship's kind attention to flag 2, page 3 of the compendium, your Lordships. Much obliged, your Lordship. To conclude the same, it can be seen that it was stated that best of best grounds within the four corners of law have been provided in PCI's order, and this negates the petitioner's sole ground of challenging the order in case 42 of 2021. Moving on to the merits of the case, your Lordships, it is humbly submitted before this honorable court that in the present factual matrix, the meeting and discussion amongst PKE Mumbai Limited, EBNR Celtic Private Limited, and TDS Tech Life Private Limited and others, the manufacturing company's conduct does not violate Section 3(3)(a) and Section 3(1) of the Act, which deals with the agreement amongst parties to coordinate pricing, your Lordships. The premise of the present issue, your Lordship, will be twofold. First, that there is no agreement to fix prices amongst the manufacturing companies, and second, in arguendo, assuming but not conceding the agreement as neither caused nor is likely to cause that is appreciable adverse effect in the market, your Lordship. If the Lordships are with me, the Council seeks permission to continue.
What's the agreement? The competition law, we are not talking about an agreement under the Indian Contract Act. There is a formal agreement, offer, acceptance, consideration. Here we are talking of a cartel, which is a civil conspiracy, which has been secrecy executed in darkness. So even a nod or a wink may constitute an agreement. So therefore, here you are saying there is no agreement. Now, are you looking for an agreement on a stamp paper?
The Council will be submitting the grounds for submitting the same to your Lordships concerning your kind query. An agreement under the Competition Act has been defined under Section 2(b) of the Competition Act.
Then, fine. What is the evidence in this case or lack of evidence in this case that you please allude to what you are expecting if there is a concerted conduct? All 3-4 people they are meeting, holding a meeting, a cocktail in a hotel. We have to draw some inference. It is a civil statute, not a criminal. Where we have to prove the guilt to the head beyond reasonable doubt. It's a preponderance of probability. They all have met. Now, when competitors meet, they don't discuss whether they discuss pricing. The great economist Adam Smith said. So you please throw light on that aspect instead of harping upon there is no agreement, there is no agreement. Of course, it will be very difficult for a regulator to argue as if there is party can stand.
As a regulator, your Lordship, you are just explaining the merits of the CCI order, your Lordship. Coming to the part where how the councils are arguing that there is no agreement in the present case, your Lordship, the council accepts the cartelization can be inferred from circumstantial evidences, but in the present case, the council contends that there was no agreement since the meeting of minds on prices among manufacturing companies were absent. Your Lordship, the council humbly submits that the latest law of the land has been laid down in cases of cartelization by CCI in the case of beer cartel and paper cartel in 2021. Beer cartel in October 2021 and paper cartel in November 2021, your Lordships. If your Lordships may refer to the council seeks the kind attention of your Lordships to flag 5 of the compendium for the respondents, your Lordship. The compendium for the respondents, your Lordship. Flag 5, your Lordship, page 2. In para 23, the highlighted portion. Your Lordship, this will be. In the highlighted portion, your Lordship, the council shall read for your Lordship. In view of the commission, even mere exchange of commercially sensitive pricing information amongst certain parties compromised the integrity of independent bidding process and was likely to stifle competition amongst them in the tenders floated. The part to be noted here, Your Lordship, is the exchange of commercially sensitive pricing information. Here, Your Lordship, the Council contends that in this present case, even though the manufacturing companies met and discussed certain information, none of that information was priced and commercially sensitive in nature. Your Lordships, the Council here seeks the kind attention of Your Lordships to flag number 1, para A. This is the moot proposition.
The moot proposition itself.
Yes, Your Lordship.
I will read. Similarly, other leading mobile manufacturing companies have decided in a confidential meeting to offer special discounts. They are talking about price. It is from the moot proposition itself that they were talking about price. The strict no for any trade association meeting. You talk about your welfare, you are not happy with the budget, some tax rates, common issue concerning the industry. But when you are talking about matters commercial, as I see, the most pernicious activity is price fixing. You are talking about discounts.
The Council accepts your kind concern, Your Lordship. Here, the Council submits that the manufacturing companies only decided to offer special discounts. There was no discussion and agreement on the prices that would be offered. It is also important to note that the fact sheet is silent on the nature of these special discounts. They can include a wide variety of offers, such as the one employed by Google in offering free YouTube Music Premium with all of its smartphones, or the extended one.
Even the latest CCI ruling here, they said even an exchange of information. Here it is a direct meeting to offer discounts. So that ruling, the threshold, you are much more beyond that. There, the standard was very low. That even if you exchange the commercially sensitive information, exchange of information without even acting thereupon or not, that standard was very, I must say, different. Here you have come a long way. So direct discounts you are talking about. In fact, I must tell you, just for educative purpose, the proper argument can be that there is a crisis started where industry is in pattern and there are redeeming features. So crisis cartel is a concept known in economics and well accepted by the competition authority. So very well taken. But now to say the needs of this proposition that you have said be fair that yes, we have to because we have collective bargaining. That is how we can only survive. That is, I think, a plea which you may persuade on efficiency grounds. It is also in the interest of the public policy that there are more telecom players, and it is more a survival, act than an act to reap supranormal profits through a cartelization. The telecom sector is bleeding now. They made a submission that they made profits and all that thing. It's a proposition text may not be clear. But if everybody is earning profits, then there would not have been a problem. In profit markets, there is no need to cartelize.
Your Lordship, the Council acknowledges your kind suggestion. The Council was getting to crisis cartels towards the end of her submission. The Council accepts that the term crisis cartel is used in two ways: to a cartel between private firms that is not approved by the state, or to an agreement between firms that a government body sanctions during a period of economic distress. The Council will proceed with her submissions regarding crisis cartel towards the end of her submission and seeks permission to proceed with the current arguments. Much obliged, Your Lordships. Your Lordships, the Council, in the beer cartel case, what the Council was getting to was that what the Commission laid down was the sharing of commercially sensitive price information. And what has been discussed by the parties in the said meeting is the current prices. Current prices are publicly available, Your Lordship. No future prices have been discussed, and if the information discussed is not sensitive in nature and is publicly available, the discussion and mentioning of such information cannot amount to the cartelization or an anti-competitive agreement or any sort of agreement, Your Lordship. On the point of discounts,
It is not in income, discount is pay a price.
indeed, your lordship,
But the pricing strategy and don't consider discount strategy, it's a bit confidential and commercialism. Then not be that at all.
indeed, your lordship, the council acknowledges your kind concern and here submits that the discussion was in context of the Great Depression in the market due to the actions of CPLC, which is the largest player in the market. In para 7 of the fact sheet, your lordship, in para 7 of the fact sheet, your lordship, in the petitioner's compendium, it is highlighted, your lordship. In the respondent's compendium, flag 1. Indeed, your lordship. Only the Competition Commission was made party to this present suit by the.
What is your role? Are you a necessary party or proper party? In fact, we will ask them as well. They have not completed the party which are affected. They have completed a regulator. Now, of course, we will come pursuant to our notice. So we have to leave it to that. Which what level you have to assist at another issue.
The council humbly submits that the council is present in this case to assist as the sectoral regulator on competition on the merits of the order passed by the regulator.
Particularly in case like this,
And
where
then we have a
get the
just
authority,
one,
where
two, three
vote of
shots.
first is
Create
create a party, proper understanding. Create a vote, ask for your resistance,
And under
investigation, or vote or whatever.
participants.
Then your vote should properly be there. Order is there, it's for it, it's for it, that is speak for it. It is left to your lordship to pass an appropriate order.
And to make available.
Far no further.
Yeah.
Pardon, your lordship.
There are we see the parties are trying to support their order.
Just make available records for clarification. And of course, it affects your views to them.
Indeed, your lordship.
What was the subject?
The council is It is saying the council humbly submits that discrimination of any of the building of the flat cell 8, 9 and 10. Logically means the flat cell 8, 9 and 10 shows logically means the flat cell 8, 9 and 10 of the so that the anti-barrier is within the kind of made more. Products contribute more to the benefits of the consumer, including products.
There, once an agreement has been shown to fixed price for unit production, then there is a certified production which will take place. This is already taken. So why are we letting it in section 19? It is important because there was an agreement to do the communicating safety. The letters are for vertical agreements, not for horizontal agreements. For this, there is a version. We
Your Lordship, the council accepts your kind concern and would like your Lordship to move on with the submission on the presence of crisis part of the present scenario, Your Lordship. The council company submits to your Lordship that the term crisis pardon has been used in two ways: to a cartel between private firms that is not approved by the state, or to an existing firm that the government body sanctioned during a period of economic distress. The first private cartel may contrary to the competition law of the jurisdiction in question, while the second kind of crisis pardon may require an exemption from that law. In the present case, Your Lordship, the council humbly submits that due to the economic distress in the market, owing to the absence of a dominant entity, to the economic distress brought by the COVID-19 pandemic, the government, the competition authority, has decided on strategy. State board business center. Recently favored on cartels. That these questions are of great relevance to developing countries, which the country of nation is Your Lordship. And with fewer developing countries which have fewer public policy instruments, this is over to which is integration of the present proceedings with Your Lordship. Your Lordship's in India, development perspective to competition law becomes all the more necessary. Efficiency. In the absence of justice, in the absence of justice, governments and authorities,
during COVID. CCI advisory specifically said businesses can coordinate their action without raising the heat of regulatory higher, because that was the need of the hour. So we the research that advisory as well, because precisely for this sector, when the government transportation are limited, so you can allocate market and south I will take care, north you take care. Normal it is market allocation pattern. But for efficiency, particularly when mobility are restricted, so it itself is an advantage. Just for that.
If you are quoting Article 21 means the Article 21 applied institutions, then individual rights to write in the document.
it is used in the present case as basis for expanding the power of the university. That the commission can develop new jurisprudence for economic efficiency in the market development.
Given an individual right, it's not an institutional or aggregate right. Would you say that a company is right to write and work with exactly for its economic consequences?
The council
You have to support a right. You can respectfully distinguish the Supreme Court judgment and referring to Article 21. Next. Okay, that's it.
No person will be prescribed. Now section 19 uses the word certificate. But if you see 14 and 21, they use the word person. Now, do you have any of this on what is person? That includes a corporate citizen.
The council is not aware of the exact precedent in your.
And so, is no excuse for a government. How you can excuse for that? So you can say we conduct a research and come back.
The council will come back to support the city. The council. We need a lot of this. The council is committed to continue the constant crisis. The Lordship for India has the report asking questions which are distorted in the promise, using our stop the power. Your Lordship, from the specific perspective of power, is lay down my in particular, the factor of the particular benefits. Improvement in production of goods and services. Readiness of production. What are finance which is relevant to CPI and related to the possibility of infrastructure or the economy. For example, the CPI